Cobell. Cujo is walking in the door. Hello, Stacy. She is our attorney for the hospital and is an expert at bylaws among many, and compliance and many other things. So Stacy has been the author of most of the changes that we see here. I want to give the opportunity for any member to disclose potential conflicts and their belief that they can be unbiased and able to participate, or that they elect to recuse themselves. Any conflicts of interest to report? Thank you. Do we have any public comment? David, at all of our meetings, the public is invited. They come and sign in, and they're allowed 3-minute maximum time to say whatever they want to say. So, again, a little history. We started working on the bylaws as a matter of routine a couple of years ago. We've had some change in leadership, and we've met I've met with the committee twice. Derek? Derek, do you know David? Derek's with Metro Legal. And we pretty much finished up what we wanted to do and presented it to the board and voted on it last month, only to discover that we had not distributed the proposed changes in the appropriate fashion, which we're prepared to do for next week's meeting. In the meantime, some suggested committee changes came forth. I believe through the administration, Janet gave them to Stacy, and you'll see those in here. Those have not been presented to the board, but I thought we would go ahead and discuss them and deal with them today. So I don't know a better way to do this than to start at page 1, which we've done before. And I've got things marked. There are some very small changes, like on page 3, the word maintained is put in there because the Metro Hospital Authority does not own this building. It is owned by Meharry Medical College, and we maintain it but not own it. And then in section 2, objectives, the terms long-term care and assisted living are deleted from there because this organization doesn't currently do either one of those things. Heading to page 4, qualifications. Heretofore, well, there are to be 11 members of the Hospital Authority Board, and 3 are to be licensed physicians. Currently, we have 3 licensed physicians. Before, it said that one of them had to be has special training in psychiatric medicine. It is very hard to find psychiatrists who are available and willing to attend all these meetings, but we found a stellar clinical psychologist, or not we, but the mayor did, and she was approved to the board and has attended one meeting. The Metro Council felt that she could represent this interest in mental health as well as a psychiatrist. They actually changed the statute and the what is the name of the document that they changed? Metro Code, and which you could argue supersedes what our bylaws say, but we put this in our bylaws that basically said that one member shall have special training, practice, and experience in the field of psychiatric medicine or psychology.
I'm just going to add that the blue language is something that I added to exactly track what the resolution said, so it matches it.
Thank you. Okay. So for what it's worth, our members approved this last month, or tried to. Derek?
Since the qualifications cite to the two prior resolutions, it would be my recommendation that you add the recently adopted resolution 2, since that's how the psychology language became adopted. In other words, it says pursuant to Resolution 99-1412 as amended by Resolution 2016-309, there needs to now be a reference to the third resolution. I don't have that number available, but I would be able to provide that. And then you're up to date with the current resolutions that affect the membership.
Sounds good. Okay. Section 5, I think that these additions are just getting this, these paragraphs up to the way they should be. They don't change anything. It makes it clear that the, like a lot of things in city government, the votes had to be approved by the entire membership, not just the people that are present at a certain meeting.
May I ask a question about this, section 5? There's a reference in the second paragraph to, if I'm reading the red line correctly, Metropolitan Board Council, and then in talking about the term of a board member, and then the next sentence strikes council and says Metropolitan Board. I'm not sure. Does that? I assume that means to refer to Metro Council rather than board, but I'm not sure what the.
I think it should just say in both places Metropolitan Council.
Okay, that makes sense to me.
I think there were probably changes that got lost in the iterations.
Okay, so
Thank you.
eliminating board and putting council in the second one. And Stacey, are you the official keeper of these changes, or both of you doing
I am.
it? Okay,
I've got
thank
this
you.
going.
Thank you very much. Okay, so on to page 5. We just have a little grammar and capitalization. Closed sessions. Now, so we occasionally have closed sessions in Metro board meetings. The question has come up recently whether a committee can have a closed session, but we can discuss that separately. And the current bylaw says Tennessee authorizes the board to convene an executive session closed to the public in 2 instances. 1, to develop marketing strategies. 2, to consider strategic plans. And I noticed that sometimes we have met to review legal advice concerning pending or threatened litigation. So that was added. However, if you go 2 paragraphs down, it already says the board also has the authority to convene an executive session for the purpose of reviewing legal advice concerning pending or threatened litigation. So that was already in there. Which way should we have it? Well, I don't think we need both. Are they saying anything different? Derek?
The last paragraph accurately states that those sessions, you don't have to be in a public meeting and then move into the closed session. You can have an executive session with an attorney to receive advice regarding pending or threatened litigation. You don't even have to have that during one of your regular open meetings.
Which is different from the first 2 reasons
Correct.
Okay.
Which is a statute that requires you
Thank you.
first be in a public meeting and then have motions to enter in, or the chair actually state that you have to go into one for either of those two reasons. So they're really distinguishable under the law.
Yeah, okay.
So am I understanding you say in the first sentence, we ought to strike number 3? Because it's separate from the paragraph. Okay, we'll strike. So we'll strike 3, and it'll say 1 and 2, period.
Okay, any discussion about that? And I have to admit that this is a result of my reading that first paragraph and saying we have to change that and not really reading down. Okay, so we're going to eliminate that. In each instance, the board cannot deliberate towards a decision, vote to authorize any action. We need a comma there, and then approve any marketing or strategy plan. Agreed? Vote to authorize any action. It's missing the comma.
Okay.
Okay? All right. Next page, participation in meeting. I would take you down to the last sentence there. Any board trustee who participates in a meeting via electronic mode may not vote on a pending issue or matter before the Board of Trustees or the committee that is then meeting. And then it goes on to make an extremely long sentence. I would recommend that we put a period at the end of meeting and start a new sentence. However, the board trustee shall not count towards a quorum. Reads better. Thank you.
There's also a typo in the second sentence. The affirmative vote of a majority of the Board of Trustees.
Thank you. Okay.
And it's there's another one in the red line of that. However, the Board of Trustees.
Okay. Section 8, and David, we have struggled sometimes to get things done. In fact, the July and August meetings of the board did not meet because of lack of a quorum. And so the previous iterations of the Bylaws Committee put this blue sentence in. If a board member fails or indicates inability to attend 3 consecutive meetings, the board chair shall counsel the member to determine their ability to fulfill their duties. If a board member fails or indicates inability to attend at least 50% of regularly scheduled meetings in any 12-month period, the member may be recommended for removal. So, first of all, this is not meant to be retroactive, nor does it state that. The reason that we put in indicates inability to attend is that if we didn't have the meeting because you said you couldn't attend, then that is counted, as a non-attendance in this structure. We like to good people on the board that are busy doing other things, and people have families, and that's understood. But when we go 3 months without a meeting, we're not approving contracts, we're not approving new medical staff appointments, and we actually, Derek helped us to look at other hospital boards and to see whether anybody had anything like this in their bylaws, and we never came up with anything to borrow some wording from. So
I actually found something today.
Oh, did you?
Jackson, Madison, I'm going to mess up their name. They do 80% of attendance. Get to make 80%.
Okay. So this is I would personally make this stronger. But it's a start. It's a discouragement. It's nothing mandatory. It doesn't say the member will be recommended for removal. The removal process would be that the board chair would go to the mayor and say, we recommend this person to be removed, and then the mayor would have to take it to the council. So even the mayor can't remove somebody. So this is meant more as a deterrent than action. I mean, I personally would say the member will be recommended for removal, but there's some sensitivity, honestly, particularly because we have one board member who has the most difficulty attending. So, we want people who will help us get the work done. This actually passed unopposed in our attempt to go through this last month. Any comments or discussion about that? Okay, Article 4 talks about the election of trustees. An important thing in here that we ignored the last two chairpersons, or at least the one before last was elected without getting the right number of votes, because I didn't know about this, but a chair is selected by the majority of members of the board, not the majority of the members present at a meeting. When Frank was elected, we knew about that. He got all the votes he needed. And there are a lot of things that should happen yearly in the board, and we don't always get them all done. I mean, some of them are evaluating the CEO, some of them are getting officers elected. So we put in here elections for the officers will occur each year in June. The fiscal year ends in June.
I have a thought about that.
Yes.
Should it change to say each year in June or at the next meeting at which a quorum is present? You don't want to be in violation of the bylaws as happened this past summer.
That makes sense because we were out of compliance. We would have been out of compliance this year. Frank?
So it'll just say, or at the next meeting at which a quorum is present.
Well, a quorum's present at every meeting, or we don't meet.
Yeah, but if you're not meeting, then we would still be in violation. So you're right, the quorum doesn't matter, but it would be the very next meeting. So say, for instance, we didn't meet in June, but we did meet in July, we would technically be in violation of our bylaws. So I agree with you.
Or in the next meeting of the board thereafter.
Yes.
Or the next meeting of the board.
I also have a little bit of a concern. Oh, I'm sorry, go ahead.
You can't have a meeting without a quorum, but you may not have sufficient members to take a vote for the officers, even if you meet quorum.
We have a quorum. We have enough.
That was going to be my next.
You'd only have 6 members to be a quorum, but you'd have to have
We'd have to have
7 or 8 of 11 to elect the officer.
That was going to be my next concern when it says a majority of the
it's the
board
majority. It's not 2/3. So six people can elect an officer. 6 of 11 can elect the officer. Right?
Yeah, but we need to make sure the point, you're correct, it is the majority, but we got to make sure that the point is that you could have a quorum and 3 candidates and no one achieve the majority of the board. And I think it's a majority of the board, not a majority of the people at that
is correct.
meeting.
So that's my concern, because if it's a majority of the board, if you got a board member that, is out for 4 months, that would mean we wouldn't be able to take a vote for officers, because you would never get a majority of the board if 1 or 2 people were consistently missing. So,
But it just says the election shall occur. It doesn't say the appointment. And I know we're splicing words.
Yeah, person may not have to be present.
As long as we make the bylaws just say that we need to hold an election in June or at the next meeting thereafter. That doesn't mean that, and I think it needs to be, it doesn't mean that the appointment has to occur then if we can't get someone vote, we can't get the requisite number of votes to appoint someone.
The appointment of an officer?
Mm-hmm.
Well, we don't appoint officers, though, we elect them.
Well,
So.
they're appointed by election, but
Okay.
I'm trying to kind of,
Well,
theoretically, this only says I have to have an election. If I can't appoint somebody through an election, that doesn't mean I have violated my bylaws.
okay. I don't like the wording of in June or one of the next meetings thereafter, because I want us to plan, in order to get things moving along, we need to intend and go through the motions of having an election in June and not having the chairman or somebody else say, you know, we're too busy, let's do it in July or August. So how can we say that we will have them in June unless,
Well, can part of that be practical, right? We all know June and July are the hardest months of the year to get people present because of vacationing. Do you need to, rather than wordsmithing that, is the real issue that we need to change that month to maybe April or May when you have more likelihood of having a quorum present? And I guess you're doing that for the fiscal year.
well, I'll say in 4 years that I've been on the board, we've always had a quorum in June.
Until this year.
No, we had it in June. We didn't have it in July or August.
Okay.
I just don't want to put in here the option that you can just like put it off to the next month. And so July and August are actually the hardest.
Okay.
And so if somebody decides for some other reason than quorum, and we're not going to have it in June, then we could end up in September like we did this time. Derek?
I would prefer that what you're really trying to state is when the election of officers will be scheduled. You're not necessarily able to mandate when they will take
Okay.
place. So I would keep the thought towards the election of officers will be scheduled each year in June. And if for some reason you're unable to accomplish that, that doesn't forbid you from moving until the next meeting and not that you'd be necessarily forbidden. I mean, we'd have to have some practical interpretation. But I think you're getting at scheduling it earlier rather than later. And none of us can sit here and really predict when members are going to be available for meetings. That's just unfortunately impossible. But
And I like that, and we might even, when we get to the nomination committee, say the nomination committee will convene in time to submit a slate for an election in June. Frank?
I guess I'm still a little concerned on the next sentence that says a chairperson for the Board of Trustees shall be selected by majority of the members of the board. And if we have 11 members on the board and 6 constitute a quorum, then we wouldn't be able to have an election unless all 6 voted, I guess, favorably. So, I mean, that's the only time when we would vote on something that is not just a majority of the members who are present.
Mm-hmm.
I mean, every decision we make is based on the majority of those members who are present if we have a quorum.
So we had this happen in the last, a year ago, in the delayed election a year ago, and I think I happened to be chairing the meeting. And a couple of us, when we realized we weren't going to get there, changed our votes so that we could go ahead and elect the person that the majority of the people there were going to vote for. I mean, you can't rely on that necessarily, but I guess anytime you have
See, I would have it just say would be selected by a majority vote,
Well,
and not necessarily. I mean, not necessarily a majority of all members, but a majority of those who are present when the vote is taken.
so.
well, tell us the background of why it is this way. I mean, Metro Council does it this way when they appoint you or me.
So I don't know, the normal reason you do that is because the chairperson is the chairperson of the entire board. And so the notion there is that when you are appointing someone for a position of that nature, and that you would want that person to have the backing of the majority of the entire board. I mean, you start word splice. I mean, when you have 11 people and you have 6 of them there, and 6 people would vote as a quorum, it makes less of a difference than when you have a bigger board. But the notion there being that, in general, you would want the chair of the board, a position of that nature, to have the backing of the entirety of the board, and not just a quorum of the people present. Because, right? But with 11 people and 6 people making up that quorum, I think it makes less of a difference, but that's the reason why you normally want the entire board to vote.
Is there a general practice for Metro boards and commissions on this? Is there some information that we can get? I mean, I have some familiarity with nonprofit boards in general, but not Metro boards, and I'd be curious what the general practice is among boards, if we know.
For appointment for members of boards, Metro requires that it's the majority of the entire Metro Council. How about the election of well, let's see, I guess the vice mayor runs the council. Would they elect officers in the council? I don't know.
And for other boards, do we know whether the majority of other Metro boards require a majority of the board to elect officers?
I don't, I can't
Okay.
on the top of my head speak to that. I'd also have to check, one thing about your bylaws, because you're a quasi-independent entity, yet a lot of the material in here is adopted after Metro code provisions that may be applicable to our boards and commissions in Metro itself. And so I'd have to go back and research the Metro code and perhaps even the Metro charter to see if it has such provision. To answer your question with, to be informed.
Yeah, I'd appreciate that, just to have a point of reference. And what Stacy has said makes a lot of sense to me, that when you're electing officers, it is on behalf of the entire board, so a majority of the board. That rationale makes sense.
And I think, to take the other side of it, I mean, you could imagine a scenario where you have 6 members present, and the 5 of them that were not there happen to support a different candidate, and
Although they wouldn't be able to elect them, but yeah, I don't think in this, it's the numbers here make less of a difference. But
and the other thing I would say is that, again, I've been through 4 elections, and we haven't had an impasse. Now, a couple of times it's because we didn't follow the rules, because we didn't know about it, but I am in favor of leaving it the way it is. Except for saying election of officer will be scheduled each year in June, scheduled for the June meeting each year. I don't want to come to June and say, hey, let's schedule the election. So it'll be scheduled for the June meeting. Yes.
May I ask a clarifying question? If we have 11 seats But we only have 9 current members. Does that change the majority to
Yes.
5 instead of 6?
Derek and I talked about this.
Do we need to note that?
Majority of members.
Current members.
If you want it clear in the bylaws, it could be subject to interpretation otherwise, but you could state of the seated members, and then it's clearer
Okay.
than a veil.
Could we do that? I'm just-
But, I mean, to Stacy's point, once you get back up to full membership, you may have a chairperson that's not in line with the majority of the then sitting members. But again, I'm just giving you legal advice on these things. I'm not giving you a recommendation. Although I will say that, Robert's Rules is replete with recommendations of whether it's committees or boards or commissions, that the whole purpose of those is to represent a informed and interested cross-section of the body. Like you all collectively for the hospital, your committees are for whatever the assigned duties are, but all of them are to reflect a cross-section of the varying opinions that the board might have.
Well,
So,
this has happened, not while I was on the board, but my understanding is when a certain mayor made a certain decision about the hospital, multiple board members resigned. So what if you had 5 board members resign or 6 board members resign and you wanted to elect an officer? You couldn't do it because you couldn't get a majority of 11, but you could get a majority of the seated members.
Sure.
So I like the clarification. And if seated is the right legal term, there are 2 places we would need to put that in there.
I think one of the things is, I'd like to suggest that we reserve making that decision to do a little more research and maybe not at this round of changes, because I could argue that it says the board shall be composed of 11 members versus up to 11 members, in which case I could more readily lean towards seated if it said up to, but it says 11, right? But I'd like to think on that, and I think we need to get these out today. So is that something that we should reserve to put a little more thought into and come back at a point?
I'm comfortable with that because our attorney, who represents the board, has given me the opinion that this means seated members. I know, but it may come up at our meeting next week. What do we need? 7 members or 8? Here's another. If 2/3 majority is 7 1/3, how many votes do we need? Don't say anything.
That's on adoption of the bylaws issue. That's not on the officer election issue.
Well, yes, but it's still. What is?
The percentage means you have to go up.
That's what I thought. So, next week we'll be voting on these, and we need to know what our denominator is. And I feel strongly that our denominator is 10 because we have 10 members.
I like the idea of further study because it seems like there are some things to consider that we're going to take a while in this meeting and maybe consider it. And the other thing about the word seated is if you introduce the word seated into this particular provision, then you change the meaning of members for every other time, for every other vote. So when we go back to consider it, I would think about what it means to introduce that term because that's going to have implications for the silence and the rest of the bylaws, but not something we need to hash out, I think, now, but something to think about.
And just for clarity, my opinions are based on, or not driven by one way or the other, but there are other boards and commissions that use seated for the purpose of them being able to still conduct business and so forth. Just like at the end of your terms, if your successor hasn't been appointed and elected, you still continue to serve until your successor is appointed and elected, whether you're an officer or even a member of the board. And that's so that Metro and its boards and commissions can continue to conduct business.
Makes sense to me. I would think of that as a definitional provision, so there would be somewhere in the bylaws that it says when the bylaws talk about votes by the members, it refers to the seated members, and then we take care of that in one.
You could do it that way, or you could say unless otherwise provided it's
Correct.
seated members or
Right.
something. And then have options where you think it's more
Yes.
appropriate to have the fully appointed board as opposed to periods of lapse in full membership.
Okay. So Frank suggested something. Remind me what it was.
He had, I'm sorry, go ahead.
No, go ahead.
He had suggested that on the second sentence of Article 4, he was concerned that it's a majority of the members of the board versus he's concerned about not having the word seated there.
Yeah. Okay.
But, Article 3, Section 6 may well already address that. I just think it's hard to answer that without really studying the language of this.
Well, I think his suggestion was majority of members present at a board meeting, not
Okay,
seated
present.
members. So I'm not in favor of that. Are you in favor of that change?
As I sit here now, no, if that results in 3 board members electing officers, I think,
Okay.
from what I understand, that would not be a sufficient support of the
So
board
the
for that
majority
type of
of this-
office.
But so if you go back to just go 3 paragraphs above that, participation in a meeting, second sentence, it may already address that question.
I'm sorry, what's that reference?
It's 3 paragraphs up. It's Section 6 of Article 3, participation in a meeting. It says the affirmative vote of a majority of the, it should say a majority vote of the trustees. I'm gonna take the word board out. Of the trustees present for a meeting at which a quorum is present is the act of the board, except as otherwise specifically provided in the bylaws or by law. So when you come down to Article 4, because it doesn't specifically say otherwise, the majority vote of the people present at that, the majority vote at any meeting. So it's already the way Frank suggested.
You don't read that to be one of the exceptions specifically provided where it says shall be selected by a majority of the members of the board?
Yeah, this,
I think it's probably, I think no one's thought about it. So it's
Yeah.
probably, we could argue it both ways is the problem.
Yeah,
That's what
that's
I
why.
was saying here. Is
I think you
Needs
would
to
be
be
on solid
clarified.
ground argue. It's unclear.
Yes, reason to clarify what we
So
want to
you
do, I
could just
guess.
say a chairperson shall be elected by majority vote. That would then default you back into Article 3, Section 6. I'm sorry, these Roman numerals are going to get me.
I think this is the way it is for a reason. If you say by majority vote, I can imagine the pressure to get, certain candidates, to get certain people to the meeting to make sure that their candidate gets elected.
They should be at the meeting anyway.
Well, I know they should, but believe me,
They should incentivize everyone to come.
yeah. Well, we have, I don't sense that there is a majority of the people, of the members of this committee who want to change this today.
May I ask on that question, what are we doing in this committee? Are we going to vote on recommended changes to the bylaws to the board for approval?
So.
And how do we want to do that provision by provision, or do we want to make these changes and then?
My hope is that at the end of this, you will read the things that we discussed and agreed on, and we will approve all of them at once. And that's what we'll propose to the board.
That's right. And then and after that, just by way of procedure, I'm going to race back, make those changes, and get them as soon as possible to the wonderful Janet Lester here so she can mail them out, so they can go out as required by law.
They have to be mailed today.
Today.
Because it's
That's
10
all.
days.
That was one
from
of the
meeting.
reasons I was saying maybe in some of these things we think about them a little bit more. It's a lot to,
Okay.
but I think you're right that the sentiment is to leave it as is.
Yeah, I don't think we have sufficient sentiment to change it.
For me, unless research and study after this meeting shows something different, the rationale that you articulated for why this would be different than a normal vote, I agree with.
Okay.
May I ask a question? This is purely a question, not to introduce more complexity. But on section 6 of Article 3, limiting voting to members who are present physically, is that a legal requirement, or is that the preference of the board to not allow people to vote from virtual meeting?
Currently, the state legislature has chosen to not grant authority to administrative bodies. Not only may you not vote electronically, you also are not permitted to communicate electronically. It must be business conducted at an open meeting, and physical presence is required. Now, I should say to vote or to participate in the meeting. A member may listen into one of the meetings, but may not speak nor vote. But it's under the Tennessee Open Meetings Act, which governs, unfortunately for us.
Yes, no, I understood. That's what I thought, but thank you for clarifying that.
Okay. All right, next page, Article 5, Committee Membership Standards. The board chairperson will also designate a committee member to serve as a committee chair, subject to board approval. Committee appointments will occur each year in July. And this is just another attempt to, the agenda gets busy, and just for the new chair, which we elect every year, that the month after the chair is elected, we'll make committee appointments for the year, and the appointments are for a year. And we've kind of fudged on that too. The committees just kind of keep going. So that's the reason for that. If you go down to section 2, it lists the standing committees, and I don't know how long this has existed like this, but it's certainly longer than I've been here. And the last paragraph says, at a committee meeting, a quorum, while not required for the committee to conduct business, shall be the majority of the number of members of the committee. Now, that's new to me, because we've had committee meetings canceled because we didn't have a quorum, but this says the committee can conduct business anyway. Am I reading that wrong?
Where are we? Here.
And why would you even define?
I would suggest that means that a quorum isn't present to have discussion, but a quorum is present to take action, is what you normally read that as.
Well,
I
it
don't,
says they can
I don't
conduct
think a deliberative action could be taken without a quorum under the Open Meetings Act.
so they can conduct
So state law
business.
would supersede this, in my opinion.
Okay, but we could still meet.
Well, as the,
We can.
anybody could meet. The only official action that can be taken at such a meeting, though, is that we move to adjourn because we do not have a quorum.
Well, this says we can conduct business.
It's superseded by state law, in my opinion, respectfully.
Okay, that's what I want to know. So we need to change it then. If we don't, it doesn't make any sense to me.
So we're going to take out while not required for the committee to conduct business. So it'll read, at a committee meeting, a quorum shall be a majority, blah, 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 et cetera.
Yeah. It makes sense to me. That puts us in compliance with state law. committee should meet as often as the committee itself, where the board determines the necessity. The minutes of the committee shall be maintained by the recording secretary. That's Janet.
And in all candor, I mean, these could have been adopted before, but there's some subsequent case law that speaks to where the originating body, which is Metro Council, formed the hospital board. So when you trace your origins back to the legislative body, all of the subsidiary bodies are subject to the Tennessee Open Meetings Act under case law now. So that would mean Metro Council subject to it, therefore the board is, and therefore all of the board's committees are subject to the Tennessee Open Meetings Act requirements. And in those, there is a provision that requires that quorum be present to conduct business.
Most of the committees have 3 people, so if you only have one person that can come, you know, you're not going to conduct any business.
You couldn't conduct business with one. There's no way to make a motion in a second and then have
Okay.
everything would die for lack of a second. So it's just an impossibility.
Okay. Now, on the next page, number 3, Medical Staff Committee. So we've kind of struggled with the Medical Staff Committee because they have certain responsibilities, and one is to receive recommendations from the medical staff and approve all appointments of responsibilities within the medical staff, definition of scope, privileges, appointments, reductions, extension, etc. So every month on the agenda is approval of medical staff appointments, and we basically have had a medical staff committee which has never met. We have the chair who reports at the meeting, but all the chair has done is read what we've already read, who the appointments are. To me, the responsibilities would require somebody on that committee to know something about the appointments and to have some communication. And that's why I have put this phrase in blue. This committee will convene as needed to review practitioner credentialing applications in consultation with the chief medical officer. The committee may designate one physician member to review and professionally approve credentialing applications that meet the Joint Commission of Medical Staff law requirements. The committee's provisional approval will be subject to the full board's subsequent ratification. I just want to make it where the chair of that committee communicates with the chief medical officer before the meeting, or maybe even attends the credentialing committee, because I can tell you when we have somebody on here and there's a question as a board member, as a physician board member about it, there's nobody in the room that can answer any questions about that. Never has been, because nobody was at the meeting. And now, in the last year, we've had the chief medical officer attend, but that chief medical officer is no longer a part of the organization. As a physician, I'm going to volunteer my services to be on the medical staff committee and take that role. So anyway, I don't recommend any changes in the description of the medical staff committee except for adding this, that the committee will be in consultation with the chief medical officer.
I appreciate that. I especially appreciate that it seems like a very valuable service and you're volunteering. And as a lawyer, I'm very comfortable in a bylaws committee because words and minutia are things that I do for a living, and really appreciate your service in that capacity.
Thank you. Okay, now we go to section 4 on the next page, and everything that's in blue on this page and the next page, this is the first time it's been considered by this committee, and this suggestion came through Janet to Stacy, and Janet, presumably it came to you from Dr. Webb. And so it is an interesting thing that the hospital administration has suggested changes to the HAB, and here's the reason for it. The suggestion is to eliminate the compliance committee, and the concern is that compliance issues perhaps are better discussed not in a public meeting. And therefore, the suggestion here is that the board appoint one of its members, the designated compliant oversight board representative, to represent it in the oversight of the hospital authority's compliance program and related policies, including the hospital authority's compliance with federal and state laws and regulations, and compliance with hospital code of conduct and related policies by trustees, officers, employees, and those providing services for the hospital authority. The designated compliance oversight board representative will report to the board from time to time as such person deems necessary and appropriate. My initial reaction to this is I would not want to be the board member who's the designated compliance oversight board representative, and both of our attorneys here have I've discussed with, and I've been educated somewhat in how compliance is a legal matter and not a a board matter, and so this puts this one person in a very difficult position of having to make decisions whether to take things forward or to whether to just say they're okay and never mention them to the board. I like the idea of having a compliance committee like we have now. I recognize the difficulty of discussing some things in public, but I kind of think the compliance committee is needed to, in the possibility we need to, hold the hospital accountable for compliance issues. So, comments from either of our representing attorneys?
I haven't fully reviewed this, but I mean, we still have, as I'm reading this, there's still a compliance committee. This is just adding, if anyone wanted to take the responsibility of being a solo recipient of compliance information.
That's a good point. Now, last time we had this, the compliance committee was crossed out, and the medical staff committee, I think.
That was my omission when I was trying to put these back in. I had taken them out, and I was trying to put it back in very quickly this weekend so you could see what that language looks like. Let me hop in here if that's okay. I think the concern that the administration brings is valid, right? If there is any kickback violation, we don't want to discuss those in a public setting. And I have taken a look at, like I said, Madison County General Hospital's bylaws. They don't list a compliance committee. But I do understand, and we've spoke, I do understand the need to ensure that there is some oversight over compliance and that the board has a level of comfort that that compliance activities are taking place. I think there's a difference in what needs to be reported to the board versus specific things, and I don't think the board should get into specific compliance activities unless there is an issue that raises to a certain level. when it relates to day-to-day activities, we have a chief compliance officer, and we rely on that person to ensure that compliance activities, I hate that word, but that work is being done the way it's supposed to be. And that person ought to have some ability to come to the board if they need to for whistleblowing purposes, et cetera, right? To ensure that things are being done. But this board shouldn't be involved in day-to-day. And I get it, you can be concerned if something comes up, but if something comes up, that's technically an issue that should be discussed with council, right? Because then we need to get into the resolution of it, and I'm not sure how the board participates in that part of it. But I do think you could have reports that detail in a broader sense the types of compliance work that's being done at the hospital, the surveys that are being done, the other things that are being done to ensure that the hospital remains compliant with laws, rules, and regulations. So then I take some feedback from that.
May I just say, yeah, the way I read the compliance committee, that's where oversight is over programs and policies related to compliance. I think the full board, to her point, is subject to the advice of council if there's a true anticipated or claim of a regulatory nature. Those are executive session materials to get the advice and so forth of the attorneys. But I will state this, before the hospital could react and give direction to that litigation or regulatory action, it's going to have to come into a public meeting and vote, and it has to be the full vote or the majority vote of the board as to the direction and decisions that you all, because you all direct the litigation ultimately, but you get the advice and so forth of the lawyers. But as far as compliance committees, I think it's designed for you to have oversight of the compliance program and related policies. But now, could the committee go into executive session and get advice from attorneys as it relates to a specific regulatory matter or something like that? It could. I don't think it's forbidden that a committee.
That was
In
my
terms of a
question.
strategic response. And then let me also clarify, because I think this is important for this board to understand, that the hospital is acting consistent with DOJ requirements. The compliance function is completely separate from legal, and compliance should never do legal, and legal it doesn't report to legal. Legal doesn't report to compliance. Compliance doesn't do legal functions, but they do act in concert with each other when they need to. So if compliance brings an issue for legal to resolve, it will. And if that were that, I'm just making something up, that a contract included a kickback unknowingly, then compliance would identify that, work on, and work with legal to resolve that. But I'm not sure that that goes to the board level until there's an issue.
When I stated a regulatory issue, I meant where there's an administrative type
Agency,
of claim that's
yeah.
been made against the hospital, or it's likely to result in or has resulted in a lawsuit filed with respect to the hospital. That's what the meaning of pending litigation or likely to result in litigation. And some of those regulatory actions are just as detailed and involved as an actual lawsuit. And so you have to also get legal advice on those matters
So,
too.
a suggestion that might satisfy the legitimate concern of the administration. What if we went back to Section 5 closed session and said, Tennessee law authorizes the board or a board committee to convene an executive session closed to the public in 2 instances. And then in the last paragraph, the board or a committee of the board also has the authority to convene an executive session for the purpose of reviewing legal advice concerning pending or threatened litigation. Is that true that the Tennessee law authorizes?
A board or a committee of the board.
Yeah.
I mean, the board is entitled to break down and have special committees. You could have a litigation committee that would, I'm not saying to complicate your lives, but
So
Some organizations do that, and then those committees bring forth their recommendations and reports at the appropriate time to the full body.
So this way, if something comes up that we would like multiple board members to be aware of, to weigh in on, you could schedule a compliance committee meeting, who could then declare a closed session, or we could schedule a meeting for the purpose of reviewing legal advice concerning pending or threatened litigation. And it takes it out of the, I'll tell you what, when we have a closed meeting on a board night, we're here for 3 hours minimum. So this would take it out of that, and it would hopefully satisfy, you know, the need that the administration has to have a venue to discuss things outside of a public meeting.
And let me just make this clarification, because us lawyers are known as pettifoggers. But you have the authority to convene in the closed session, but when it's called, it's being called by the lawyer, who's saying there is a legal matter on which legal advice is required, because you could convene it all day, but not unless the attorney is willing and agrees that it's appropriate for the client.
So the chief compliance officer would have to contact legal.
Would have to get the permission of the attorney to discuss, and if it's litigation, they need to contact Metro Legal to be involved.
So we've done this, you know, we've done it multiple
Correct.
times to discuss lawsuits. And I'm saying this takes it out of the board meeting. We don't need 11 people to hear this. If we do, we'll tell them, you know, in the board meeting. But and it also takes it off the place of one person assigned to this task, which I don't want to be that person, you know.
So you're suggesting going into the section under compliance committee, and what is the addition that you're suggesting?
So
again?
here's my suggestion. We leave the compliance committee as is.
Okay,
That the suggested under Section 5 compliance doesn't make it through this committee. We keep the compliance committee the way it is, but we make it clear under these are both Section 5.
under Article 3, Section 5.
Article 3, Section 5, that Tennessee law authorizes the board or a board committee to convene an executive session.
Okay.
And in the last paragraph, the board or board committee also has the authority to convene an executive session.
Okay,
Okay?
and then we're going to eliminate Section 5.
Oh, no, we hadn't talked about number 2 yet.
Okay.
Okay, so I think that, okay, are the members, what do the members think of this? That's you.
Yes. What I think is I am digesting a lot. I know that all of these changes have been before the board and have come back. All these changes have been before the board and coming back, and what you all have suggested sounds good to me.
Okay.
And we'll continue giving thought to it as it goes forward, but I also don't want to come in here, which is at the very end of what appears to have been a pretty lengthy process to consider these and make wholesale changes.
Well, this particular part, it has not been
Oh,
this is the first time this committee's looked at that. It's been in my hands for a few months, just because I get all these papers, but
so the question is, keep the compliance committee,
Yeah.
strike proposed section 5,
A,
lower 1 to
yeah.
designate strike the proposed designated compliance oversight board representative.
That's right.
That change is fine with me.
Right.
And then we're going back into Article 3, Section 5, and saying the board or a board committee may call a closed session.
Yes,
Okay.
understood.
Okay.
Sounds
Thank
good.
you. Frank, I don't, I'm not sure whether you're a voting member of this committee or not, but I certainly would value your advice and counsel about this.
No, I think that's a healthy space. I think the protecting the administration's opportunity to be successful and not sharing with the competition all of our weak spaces, right? So that gives us a way to handle those things, and so I agree. I think that's a good
Okay,
space.
thank you. Now, let's go to proposal number 2, medical staff oversight appointment. And after reading this second time yesterday, I actually think this may be the solution to the medical staff committee. So instead of having a medical staff committee, which has never met, as far as I'm aware, you do have one member appointed, and while you're out of the room, Frank, I would volunteer to be that member, to represent it in oversight of the medical staff and reviewing practitioner credentialing applications as needed. That doesn't mean you have to review all of them, including provisional approval of credentialing applications. This is the same wording that we've read through. This is copied directly, I believe, from the current description of the medical staff committee.
So is this the role that Dr. Burleson has been?
Well, this role didn't exist. He was the chair of the medical staff committee,
Okay.
and so really all he did was read to us the appointments during the meeting. But if you ever ask him any questions about them, he hadn't attended a meeting, so he didn't really know anything about it. So I kind of like the idea of appointing one of the members to represent it in oversight. So it doesn't require a committee meeting. It just means this representative talking to the chief medical officer as necessary about appointments. And, were I in this role, I would look at those appointments ahead of time. I would talk to the chief medical officer. I would be prepared to answer any questions that the board member had about appointments. And then there's a whole lot of other things in here that I believe the responsibilities are directly copied from the existing description.
Right, that's correct.
Okay. So I personally would be in favor of omitting the medical staff committee, and then and adopting section 5, number 2, that would no longer be number 2, of medical staff oversight appointment. And I'm not sure, in section 5 could be special oversight appointment.
I was going to say, I was going to wait till you agreed on that and then tell you how I was going to fix that.
Okay, all right, comment.
So a question, it's telling that the medical staff committee never met, so it seems like some sort of a revision is needed. What does the chief medical officer and the administration more generally think about this change? Do we know?
I believe it was proposed by the
Chief medical officer.
chief medical, well, by the CEO, or maybe the chief medical officer.
Both.
Okay, so apparently they like it.
Yeah. Well, this would seem to reflect, almost reflect current practice, but anticipating someone who would have a more active role by taking all the duties of the committee and putting it in this person, like the newly created medical staff oversight person. What does it mean to, when it uses in several of these, approve and or recommend to the board certain?
And I think Dr. Martin can probably clarify that, but I will say this. I think the one issue that we have in appointing one person versus a committee, did we talk about that? The committee is the avoidance of having a public hearing on sensitive credentialing information. Is that correct? And other,
Well,
that was what I understood.
not what I had in mind. I mean, the oversight person is going to report to the board at every meeting. And, you know, if there are controversies, they will be reported.
But the details of them aren't, you aren't taking Jane Doe or John Doe and having that done in a public hearing. You may report on it generally, but you're not doing the details of some special.
Well, you'd have to decide. I mean, the only forum we've seen so far is everything's right in the board meeting. So if there's any question, it's answered in the public board meeting. And this would allow them to be fleshed out, you know, before the board meeting.
Without having a public hearing.
Without having a
Flushing it.
public
That's
hearing.
right.
Yeah.
And I think the recommendations are, so they'll receive and review information and then use that to come back at board meetings where they do make recommendations, correct?
Correct.
I think, is that what your question was?
Yeah, it was more to that, is that it says the board will appoint one of its members to represent it in oversight of the medical staff. And what I'm trying to get a sense of is what is the extent of the delegation of the authority from the board to this one person? And it seems to me when it says approve and or recommend, the word approve is what seems like it could be putting on this one person a significant amount of authority, and that may be appropriate or not. I don't know.
It should be recommend.
Yeah, let's take approve out. I like that.
Yeah, I was gonna say, review.
Okay, I like that.
It seems more consistent with what you're describing.
Same on the next one.
And C, D, F, and G.
Is that consistent with how you understood it, the
Yes.
role? Okay,
Yes.
all right. I think that would reflect that.
Yeah, I would not want to, you know, approve, you know, single-handedly
Yes.
approve stuff. I mean, honestly, the board does have to approve all the appointments and reappointments. This is just a better way than what we've been doing for the board to communicate with the chief medical officer and the medical staff. You know, personally, I would go to some medical staff meetings, you know, and so that the medical staff could send messages to the board. And if I had questions about board appointments, I would ask them outside of this meeting while I was talking to somebody who knew and who knew what was sensitive and what was not sensitive. And you know, we would avoid exposing, you know, the names of our medical staff and, you know, the details of their past history and that sort of thing. So I'm sensing approval of this, and we would have to go back where it's listing standing committees.
And delete
we
three.
would delete the medical staff credentialing committee, which was the proposal of the staff.
Okay, and then, so section 5 will just be special medical oversight appointment.
Special medical staff oversight appointment, yeah.
And one thing that was brought to my attention is going back to section 4. Special committees, do we want to take out that they have to have 3 people, just that they can be appointed as necessary?
Frank, have you appointed any special committees? I don't.
No, we had one when we were looking at the building of the hospital, the new hospital.
And you would want at least 3 people on that. I mean, so if you eliminated that, you could have a committee of 2.
It's just flexibility. It just depends, right? I mean, they're not making decisions. They might be something that's coming back to study something and come back with but I mean, it's, I
No,
wouldn't waste a lot
I
of
actually
time there.
agree with you because with a board of 11 and we already have 5 standing committees, that means everybody's on some committee at least twice, right? And so getting 3 people can be difficult sometimes.
I'm good with that.
Yeah, I'm good with that change too. Is it envisioned from the discussion that a special committee could consist of non-board members if they were limited in their authority as to what they could do? Is sort of what I'm hearing. Is that possible? Legally or otherwise?
Well, we've had members of the hospital administration serve on those committees. I don't know if we were doing so rightfully, but
Always changes on the committee. Let me just preface this. I haven't had a chance yet to digest these in consultation with the Metropolitan Hospital Authority Act, which is a body of law by which this institution was created. And so, and that's, frankly, I was trying to get some background over here a moment ago. I don't know if the act requires any such committees. I wasn't I was an attorney, but I wasn't active with Metro when these types of bylaws and that act was adopted, creating and so forth back in 98 and 99. So I'm making notes here of I need to just circle back around and see if there's some direction in those statutes that requires these entities or why they were created this way. In other words, these may have been created purely for policy reasons, or they may have been created due to legal requirements, and that's what I've got.
Well, I mean, I would say if you find that they're not required and we want them anyway,
Those are policy choices that you're entitled to make. But
So-
if it's legally mandated that these committees exist, I don't want to let you go down a path that's not permitted under the statutes. So
yeah. Well, I certainly, and I hope that you
So that
can,
makes,
by next Thursday, let us know if anything we're doing here conflicts.
but the problem will be that we've got to send them out today. As, if you change them, you do them over again.
Can't we make amendments at the time we're accepting them, considering them on Thursday?
again, I'd have to check the statute. I know the statute that I provided the site to requires they be mailed 10 days in advance. But I don't know that you would ever be able to
We'd never
vote
finish.
without any amendments. But I can't right now without reading the actual statute.
Okay, well, I would just ask that you look at these in the next week and let us know if there's something that we cannot do. But what we're not, to me, it's irrelevant whether those committees are mandated. We've looked at each of the committees, we want to keep them, whether they're mandated or not. So. Okay. Article 6 has to do with the administration, management of daily operations. Nothing is changing in 1, 2, and 3. Section 4 is new. And David, the reason for Section 4 is a lot of our meetings are taken up with approval of contracts. And we have offloaded that to a certain extent by having the Finance Committee go through each of those contracts. The Finance Committee meets an hour before. And we have a wonderful Finance Committee chair now who will give a very brief description and ask if there's any questions, because everybody's had a chance to read them in the packet beforehand. But still, there's some minor contracts that probably don't need to be considered by the board. There was a struggle for the word, but in the minutes, 6 or 7 years ago, it said that the board would have to approve every contract over $50,000. And what we've done here is increase that to $100,000 for a to a maximum of $375,000 for medical services, and that's basically if somebody wanted to, you know, pay a neurosurgeon, you know, $1 million, the board should have to approve that. But if you're looking at standard kind of salaries for physicians, and it's 375 encompass most of the paid medical staff. Okay. Anyway, that's the number that we came up with. And all of this we went through in detail in the last board meeting, and there was no controversy about it. Everybody was okay with it. It boils down to F, which says, notwithstanding anything to the contrary above, prior approval of the Board of Trustees is required, shall be required in the event of any agreement whose term, equals or exceeds 3 years, and E above, which is what I was really looking for. Prior approval by the Board of Trustees is required in the event of any contract for medical professional services over $375 per year, or for any contract over $100,000 per year. It also says that basically Bruce can approve, lesser contracts, and or that he can be given authority to do that. And in C, it says if there's an emergency, and we've had this happen, and the contract needs to be approved before the board can meet, then the CEO can talk to the board chair and then can execute an agreement, which is necessary, so long as the said agreement is no longer than 30 days. Powers of the CEO granted or delegated above may be further delegated by the CEO to any officer of the NGH, providing no such delegation shall exceed $75,000. So this is, Dr. Webb has essentially given the opportunity to comment or object to this and did not. And the 7 board members that were present were happy with it last time, so I don't really see any difficulties there.
Given the how it was accepted by the board and Dr. Webb, I don't see any reason to change any of this.
Thank you. Okay, most of the rest of this has to do with medical staff, and in page 13, we've changed the word physician to practitioner to include our nurse practitioners and so forth in the organization of medical staff. And just some very minor stuff here that, again, the board has already approved. Article 8 is about professional review. No changes. The impact here. On page 18, there's some things about proof of delivery or by overnight mail. I can't remember why we're changing that. Maybe to get
so that we're not titled. It's just for flexibility in modern.
Yeah,
Getting
getting into
so
the
that
21st century.
Could be hand delivered. Could
Okay.
be FedEx.
Thank you.
Doesn't have to be certified mail.
Okay. Moving ahead. Another proof of delivery. Article 9, NGH personnel. Just given a name consistent with the other articles. Article 12 is the one that got us into trouble. These bylaws of the Board of Trustees shall be reviewed periodically and may be revised as necessary by the affirmative vote of 2/3 majority of the membership, provided notice shall have been mailed in accordance with Tennessee Code, annotated, etc. is it okay to just leave it like that? Or should we say, for the next, when this happens again in 2 years, this is what the Tennessee code requires? I think Janet will have the institutional memory, assuming she's here. I'm okay with just leaving that. I just wanted to, some of the things we have, when they're codes, we have sort of spelled them out, but if there's no comment or objection, we leave that as it is. And in page 24, and this is under an article called Conflicts of Interest Statement Policy. And number 6 is added, I think is not controversial. No trustee or employee of the NGH who holds a conflict of interest in a transaction shall be permitted to vote on such transaction, or any such person shall not be counted towards a quorum for such purposes. Further, to avoid the appearance of impropriety by the board member, trustee, or any direct or indirect exertion of undue influence, no board member, trustee, or employee who holds a conflict of interest shall participate in the deliberation of any matter for which such person has a conflict of interest. That sounds like pretty standard stuff to me. Before we have asked Stacy to read the things that we have agreed upon in principle, and then have us agree on it as a whole. And again, I think so. Frank, thank you so much for being here. The bylaws say that you can fill in to make a quorum. I'm not sure whether you're supposed to vote or not, but
So I'm going to fix, I can vote if I'm replacing a member.
okay. Well,
So I think
are you replacing a member?
I think so, to make a quorum.
Yeah. Well, we'd have a quorum anyway.
Oh, well, you don't need me
There are
then.
2 of us.
You don't,
Well, we needed you, but not to make a quorum.
okay.
Okay, so you're not here to make a quorum. So we have 2 voting members. Okay. So, Stacy?
All right. All right, we're gonna go to page 4. This is Article 2, Section 4. One quick note, I'm gonna change SR to RS. I'm going to add in the current board resolution number from the Metro Council. I don't have that in front of me, but I'm going to add it. Section 5, right after that, I'm going to change Metro Board to Metro Council in both occurrences. Article 3, Section 5, under closed sessions, I'm going to say Tennessee law authorizes the board or a board committee. I'm going to leave in the word and I'm going to strike number 3. Then on the next page.
You gonna add that comment for me?
Yes.
Thank you.
I have it in there. I'm sorry. I should have said that. I'm going to add a comma in vote to authorize any action, comma, approve any marketing or strategic plan, et cetera. Okay. On the next page, the board, I'm going to insert or a board committee. Under section 6, right after that, I'm going to delete the addition of the word board that you see in the second sentence. I'm going to also do it where you see it below, maybe 4 lines up. And then where you see however, I'm going to put a period and say however, comma, the board of trustees, or I might just say however the board shall not count. I'm going to actually read all of this and clean up small grammatical errors here and there. So Article 4, elections for the officers will be scheduled for the June meeting each year, period. Article 5 on page 7, under section 2, second paragraph, at a committee meeting, a quorum shall be the majority of the number, so I'm deleting while not required for the committee to conduct business. On page 8, Under Section 3, Article 5, Section 3, I'm going to strike number 3, Medical Staff Committee, and I'll renumber the rest of it.
And, sorry, back on Section 2,
Okay?
we need to strike Medical Staff Committee, Credentialing Committee.
Oh, that's right. Thank you. All right. Section 4 will be special committees. I'm going to strike the language that is there and read it, and it'll read as follows. The chairperson may appoint special committees as may be necessary or appropriate, period. A special committee may be composed of one or more board or non-board members. I made that up while you all were talking. Is that okay?
Well, can you have a committee of one? Or should it be?
I didn't put how
Two.
many numbers. I just said that you can, the chairperson can create a special committee. You don't have to say how many people are on it.
That seems consistent with what we talked about, subject to research that it is, we have the authority to have non-board members be part of a special committee.
So read it again.
The chairperson may appoint special committees as may be necessary or appropriate. A special committee may be composed of one or more board or non-board members.
Okay.
Parentheses around the S period.
Good.
Section 5 will just say special medical, so I'm striking the compliance language, and it'll only have special medical oversight appointment.
Medical staff.
Medical
oversight.
staff, sorry. I'm
Thank you.
reading, my brain is ahead of my mouth. Special medical staff oversight appointments, the sentence is going to be grammatically changed to have one in parentheses and medical staff capitalized. Under A, nothing will change. Under B, which needs to be made into a paragraph, B will say, receive recommendations from the medical staff for appointments of responsibilities within, et cetera. So I'm deleting the word and approve all. C, I'm deleting approve and or. Same on D, same on F, same on G. And I don't have any other, let me make sure.
Okay. Do I would entertain a motion to, for the committee to recommend these changes to the Hospital Authority Board.
I move that we make the recommended changes to the bylaws and transmit these to the board for approval.
Okay. I second it. All in favor?
Aye.
Aye. Any further business? Yes. Okay, yes, the minutes were circulated to you. I have reviewed them in detail and find no additions or corrections. Anybody else?
I move approval of the previous minutes.
Second, all in favor?
Aye.
Aye. Okay. Thank you. And Frank, there's a letter for you and I to sign to ask people to look these over and encourage them to come to the meeting. And thank you. And I want to thank particularly Stacy and Janet, who, you know, I have harassed mercilessly over the last week, including Saturday and Sunday. And while I was walking around New York with two grandchildren, and, you know, had I been more conscientious, we would have got this done in a less cumbersome matter, but we got it done. And I told Janet, listen, we're just going to have to push this to the November meeting, and she said, I think we can get it done. So we did. Thank you. Meeting adjourned. Thanks so much.
This This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.